Here is what happens when the Supreme Court rules that a sitting president collected money he was never legally allowed to collect. He has to give it back, all of it, $175 billion, to 53 million separate importers, through a government agency whose own lawyers just filed a court document this week saying, and I am quoting the specific language here, that its existing technology and procedures are not well suited to a task of this scale. The Supreme Court said the money was illegally taken. A federal judge said it must be returned, and the agency responsible for returning it told the court it cannot do it. That three-way collision: constitutional ruling, court order, and administrative impossibility is what is sitting on the desk of every American business that paid Trump's tariffs right now. And the way this gets resolved or does not get resolved is going to affect the price of almost everything you buy. Let me take you through exactly how we got here, because the timeline is specific and the details are significantly more complicated and more consequential than any single headline has captured. The Supreme Court ruled on February 20th that Trump's tariffs imposed under the 1977 International Emergency Economic Powers Act were unconstitutional. The majority ruled that the president could not unilaterally set and change tariffs because taxation power clearly belongs to Congress. Reuters Institute: the vote was 6-3. This was not a narrow or partisan ruling. 6 justices, including Trump appointees, agreed that the emergency powers law did not give the president the authority to impose sweeping import taxes on essentially every country in the world. The constitutional logic is foundational and simple. The power to tax belongs to the legislative branch. A president using an emergency declaration to bypass Congress and set tariff rates on his own is not an emergency measure. It is a seizure of congressional authority. The federal government collected more than $130 billion in the now-defunct tariffs through mid-December, and could ultimately be on the hook for refunds worth $175 billion, according to calculations by the Penn-Wharton budget model. Trend Hunter: $175 billion. To understand what that number means operationally, consider this. The entire annual budget of the Department of Homeland Security is approximately $60 billion. The refund obligation is nearly 3 times that. It is larger than the GDP of most countries. And it was created not by a spending bill, not by a congressional appropriation, but by a single Supreme Court ruling on a February morning. Now look at what happened in the courts in the days that followed, because the sequence moved faster than anyone in the White House anticipated. More than 1,000 companies immediately sued for refunds after the Supreme Court ruling. The U.S. Court of Appeals for the Federal Circuit rejected the Trump administration's attempt to slow the refund process and sent the matter to the U.S. Court of International Trade in New York. Latestly, the administration tried to pump the brakes. The appellate court said no. Judge Richard Eaton of the U.S. Court of International Trade wrote that all importers of record were entitled to benefit from the Supreme Court ruling, and designated himself as the only judge who will hear cases pertaining to the refund of these tariff duties. Google: one judge, all cases centralized in New York, moving faster than the government's own systems can process. Judge Eaton ordered U.S. Customs and Border Protection to finalize paperwork for imported goods without including any tariff charges, the step known as liquidation. For goods that had already been liquidated with the tariff charges included, Eaton ordered officials to redo the step entirely. Latestly, redo the step entirely. That means reopening and reprocessing every customs entry that went through the system while the illegal tariffs were being collected, every container, every shipment, every import declaration. Millions of individual transactions, each of which now needs to be reopened, recalculated, and refunded. Here is where the story becomes an operational crisis and not just a legal one. U.S. Customs and Border Protection filed a court document this week telling Judge Eaton that it is not currently able to comply with his order. The agency said its existing administrative procedures and technology are not well suited to a task of this scale, and will require manual work that will prevent personnel from fully carrying out their trade enforcement mission. The agency warned that personnel would be redirected from responsibilities that serve to mitigate imminent threats to national security and economic security. New England: read that carefully. The agency responsible for securing American borders and processing every import into the country just told a federal court that complying with a lawful court order would require pulling staff away from national security responsibilities. The legal obligation to return illegally collected money is now in direct competition with the operational capacity to secure the border. CBP said it estimates that changing its automated commercial environment system will save the agency over 4 million hours of employee work. The agency suggested it could begin issuing refunds by late April after revamping its technology, and said the new process will require minimal submission from importers, New England: late April. That is the earliest timeline CBP itself believes is technically achievable. And that is the optimistic scenario, the one where the technology overhaul works on schedule, where staffing is sufficient, where no further legal challenges delay the process. Trade lawyer Alexis Early said the customs system was not designed for a mass refund. and that the devil will be in the details of the administrative process, means CEO's blog. Now look at Trump's response because it is documented and it tells you exactly how the administration intends to approach this obligation. Trump said on Friday afternoon that a court fight over refunds could take years, and he announced a new 10% global tariff would be implemented immediately, means CEO's blog to move simultaneously. First, signal to businesses that even if they are legally entitled to refunds, the legal battle to actually receive them could stretch across years of litigation. Second, replace the struck-down tariffs with new ones immediately, so that the revenue stream the government depended on does not disappear even while the refund obligation for the old tariffs is being processed. The Supreme Court said the old tariffs were illegal. Trump replaced them within hours with new ones. In his dissent, Justice Brett Kavanaugh noted the ruling lacked any refund guidance and referred to comments during oral arguments that the refund process may be a mess, means CEO's blog a mess. That word came from a Supreme Court justice, a conservative justice, in his own dissent before a single refund had been processed. Now let me show you what this means for the businesses that actually paid these tariffs, because this is not an abstract government accounting problem. It is a cash flow crisis that is already affecting real companies. Businesses have pushed for speed in the fight for refunds while the administration has so far opposed their efforts to expedite the process beyond normal timetables. To date, many importers have only made an estimated tariff payment, and the judge's order mandates that customs finalize those entries without including any tariff charges. Latestly estimated payments. That means the final bill has not even been calculated yet for millions of import entries. Companies that paid estimated amounts are waiting for their actual refund to be calculated before it can even be queued for processing. Trade lawyer Ryan Majerus, a partner at King & Spalding and a former U.S. trade official, said he expects the government to appeal or seek a stay to buy more time for U.S. Customs to comply, means CEO's blog a stay. That is the legal mechanism by which the administration can pause the refund obligation while it appeals. If a stay is granted, the $175 billion obligation does not disappear, it just sits frozen while the legal machinery grinds forward. For a small business that paid $100,000 in illegal tariffs, a stay means that money stays in the government's hands for months or years while lawyers fight over the timeline. The small business dimension of this story is the one that most coverage has missed entirely. Illinois Governor Pritzker has demanded $8.6 billion for Illinois residents after the Supreme Court struck down Trump's tariffs. The Illinois demand alone represents the refund calculation for one state, Fox News one state. $8.6 billion, and there are 50 states, plus U.S. territories, plus foreign companies that imported goods through American ports. The $175 billion total is not an overestimate. It may be an underestimate once all claims are filed within the 180-day liquidation window. Here is the timeline trap that the administration created for itself and cannot escape. All goods that go through U.S. Customs enter a process called liquidation, when the agency issues its final accounting of what is owed. Once liquidated, importers have 180 days to formally contest the duties. After that window closes, the liquidation is legally final. Trend Hunter 180 days. That is the window companies have to file their refund claims. The clock is running. CBP says it needs 45 days just to rebuild its technology. Then it needs to process 53 million individual entries. Then it needs to calculate and issue the refunds, all while the administration is signaling it will fight the timeline in court and has already replaced the struck-down tariffs with new ones that may face their own constitutional challenges. Now look at the number that makes this a direct threat to the U.S. Treasury and therefore to every American taxpayer. Refunds of billions of dollars would have significant consequences for the U.S. Treasury. The Supreme Court said nothing about whether and how the government should go about returning the billions of dollars it has collected, means CEO's blog. The Supreme Court struck down the tariffs but gave no guidance on the refund mechanism. The federal judge stepped in to provide that guidance. The administration is contesting it, and sitting underneath all of it is a $175 billion hole in federal revenue that nobody in the White House has explained how they intend to fill. The federal government is currently running a deficit. It is also fighting a war in Iran that is costing billions of dollars per week. It is also processing the operational disruption of a 250,000-person DHES workforce after its secretary was fired, and it now has a court-ordered $175 billion refund obligation that its own agency says it cannot currently execute. The Penn-Wharton budget model, which produced the $175 billion estimate, is not a partisan think tank. It is the economic modeling arm of the University of Pennsylvania's Wharton School. Their number is the most credible estimate in the public record, and that number represents money the government collected, spent, and now has to return. Trump announced new tariffs the same day the court ordered the refunds. The new tariffs will generate new revenue going forward, but they do not pay back the old obligation. They are a new stream being opened while a $175 billion drain is being ordered by a federal court, and somewhere between those two. Facts is the answer to a question the White House has not answered publicly. Where exactly does $175 billion come from in a government that is already at war and already running a deficit? The Supreme Court ruled. The federal judge ordered. The customs agency said it cannot comply. The businesses are waiting. The lawyers are already drafting the stay motions. The clock on the 180-day window is running, and the $175 billion is sitting in the U.S. Treasury, legally ordered. Returned administratively impossible to process and politically inconvenient to discuss. You have the numbers, you have the timeline, you decide what it means that the government took it, a court said it was illegal, and the agency responsible for giving it back says it does not currently have the technology to do so.